I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. The topic for the day is New Facets to Right to Life and Personal Liberty under Article 21 of the Constitution. Introduction. The sanctity of human life is probably the most fundamental of human social values. It is recognized in all civilized society and the legal systems as well as in internationally recognized statements of human rights. Every person is entitled to live their life on their own terms with no unfair interference from others. A successful democracy can only be one that guarantees its citizens the right to protect their own life and liberty. In India, the protection of life and personal liberty is a fundamental right guaranteed to citizens under Part 3 of the Constitution of India 1950. These fundamental rights represent the foundational values cherished by the people and are guaranteed against action of the state, meaning that no act of any state authority can violate any such right of a citizen except according to the procedure established by law. Article 21 of this part states that no person shall be deprived of his life or personal liberty except according to the procedure established by law, and this is known as the right to life and personal liberty. The term life and personal liberty encompass a wide variety of rights of the people, which are a result of evolution in the interpretation of Article 21 by the courts over the years. Evolution from international charters. The principle of ensuring the right to life and personal liberty was not new to the Indian constitution makers before they incorporated it into the constitution. In fact, this principle was recognized much earlier in the Magna Carta of England 1215 and in US Constitution 1791. In England, it was reiterated in the Petition of Rights 1628, and since then the observance of this principle has established what is known as the rule of law in UK. The Americans also appear to have borrowed the phrase due process of law, which was first used in a statute of 14th century. However, the expression law of the land used in England has a different meaning than the due process of law used in the US Constitution. Internationally, on a broader level, the Universal Declaration of Human Rights 1948 recognized this principle for the first time. Article 3 of the Declaration says, everyone has the right to life, liberty and security of person. Article 9 further provides that no one shall be subjected to arbitrary arrest, detention or exile. This right has also been strongly emphasized in the European Convention on Human Rights 1950 under Article 2, 3 and 5 and the Covenant on Civil and Political Rights 1966 under Article 6, 7, 9, 10 and 11. While ensuring the specific rights to life, the personal liberty, these international documents also recognize the subsidiary right at great length. These rights are often taken into account while deciding cases related to the movement of refugees and illegal migrants across national borders. In case of Vishakha versus State of Rajasthan, this is of 1997 Supreme Court judgment, page number 3014. The Honorable Supreme Court of India held that the provisions of international instruments and norms can be read into justifiable fundamental rights in order to fill any gaps or to enlarge the scope thereof as a canon of statutory construction, unless there is any inconsistency between them. Thus, several aspects of this right have evolved in Indian jurisprudence through the accepted principles of the international arena itself. Understanding Article 21 of the Indian Constitution. Though couched in negative language, Article 21 confers the fundamental right to life and personal liberty on every person, including foreigners, and these two rights have been given paramount importance by the courts. These rights enjoy a fundamental ascendancy over all other attributes of the political and social order, and thus the legislature, executive and the judiciary are more sensitive to them than to the other attributes of daily existence. Moreover, though the word person indicates an individual, through public interest litigation, under Article 32 and 226. The collective right of the people have also come to be enforced under Article 21. The early approach to Article 21 was circumscribed by literal interpretation, but over the course of time, the scope of application of article has been expanded by liberal interpretation of the components of the article in tune with the relevant international understanding. Thus, protection against arbitrary privation of life no longer means protection against physical injury or death, but also an invasion of the right to live with human dignity, and would include all these aspects of life that would go to make a man's life meaningful and worth living. It must also be noted that while the protection of Article 21 is extended to foreigners as well, the same is confined to the article for life and liberty and does not include the right to reside or stay in India. The right to life is undoubtedly the most fundamental of all rights. All other rights add quality to the life in question and depends on the pre-existence of life itself for their operation. As human right can only attach to living beings, one might expect the right to life itself to be in some sense primary, since none of the other right would have any value or utility without it. There would have been no fundamental right worth mentioning if Article 21 had been interpreted in its original sense. Article 21 of the Constitution of India 1950 provides, "No person shall be deprived of his life or personal liberty except according to the procedure established by law." Life in Article 21 of the Constitution is not merely the physical act of breathing. It does not connote mere animal existence or continued drudgery through life. It has a much wider meaning, including the right to live with human dignity, right to livelihood, right to health, right to pollution-free air, etc. The right to life is fundamental to our very existence, without which we cannot live as human beings, and includes all those aspects of life which makes a man's life meaningful, complete and worth living. It is the only article in the Constitution that has received the broadest possible interpretation. In the leading case of Khadak Singh versus State of UP, AIR 1963 Supreme Court 1295, the Supreme Court quoted and held, by term life as here used, something more is meant than mere animal existence. The inhibition against its deprivation extend to all those limbs and facilities by which life is enjoyed. The provision equally prohibits the mutilation of the body by amputation of an armored leg or the pulling out of an eye or the destruction of any other organ of the body through which the soul communicates with the outer world. Now, discussing with you the role of judiciary. The judiciary in India is playing a significant role in protecting the rights of the people, as it is evident from the plethora of landmark judgments discussed in Article 21, though couched in negative language, confers the fundamental right to life and personal liberty. Right to life enshrined in Article 21 means something more than survival or animal existence. The Indian judges are now in a commanding position to expose the area of darkness which has evaded the executive of Indian democratic setup. In the present scenario, the life and personal liberty of the person cannot be effectively preserved unless the essential rights propounded by Supreme Court under Article 21 are protected. Therefore, Article 21 includes various aspects and due dimensions, that is, right to shelter, livelihood, education, health, timely medical aid, live in healthy environment, access to road, live with human dignity, suicide, social security, privacy, travel abroad, prisoner, speedy trial, fair trial, bail, legal aid, illegal detention and custodial violence, etc. The functioning of Indian judiciary discloses that it has, through progressive and humanistic interpretation, been able to enlarge the right of suspect and accused with a zeal to protect the interest of the innocent and prevent misuse and abuse of police powers. The scope of Article 21 of the Constitution has been widened in the light of changing values of Indian society. Time has shown that the higher judiciary is not only worthy of trust in the matters of fundamental right to life and personal liberty, but also the torchbearer. Never-ending scope of Article 21 of the Indian Constitution. After elucidating upon the expansion of the purview of Article 21, it is important to understand the wide array of different rights and privileges this single right hold as per its meaning in the present era. This part discusses various case laws to examine the various aspects of right to life and personal liberty. First is right to live with human dignity. It is not enough to ensure that a person has a right to live. An essential element of life is one's dignity and respect. Therefore, each person has been granted the right to live with dignity, which means having access to necessities of human life as well as having autonomy over one's personal decision. The leading case is Occupational Health and Safety Association versus Union of India. This is a 2014 judgment of Supreme Court given on page number 547. In this case, a non-profit organization filed a petition seeking guidelines for occupational safety and health conditions in various industries, especially thermal power plants. The court recognized the state's duty to protect workers from dangerous or unhygienic working conditions and remanded the matter to various high courts to check the issue of thermal power plants in their respective states. Thus, in this case, the protection of health and strength of workers and their access to just and human condition of work were taken as essential conditions to live with human dignity. Rights over one's intimate relations. The Supreme Court, in the case of Navtej Singh Johar versus Union of India 2018 Supreme Court 4321, said that right to dignity means the right to full personhood and includes the right to carry such functions and activities as would constitute the meaningful expression of human self. In this case, a very important aspect of human dignity was talked about, the control over one's own intimate relations. The court, applying the principle of human dignity, said that section 377 was violative of Article 14, 15, 19 and 21 of the Constitution to the extent that it criminalized consensual sexual acts of the adult in private. As can be observed, human dignity is not a straitjacket idea. Rather, it involves all those rights and freedoms which enable a person to live life without encroachment upon his or her self-respect, pride and safety. Right to nutritional food, and the leading case is People's Union for Civil Liberties versus Union of India and others. This is a 2002 judgment. This case was filed by PUCL against overflowing of grains in godown, leading to food wastage and concern over increasing starvation and death of poor people in India. The Supreme Court explicitly established a constitutional human right to food under Article 21. The court reconfigured specific government food schemes into legal entitlement, setting out the minimum allocation of food grains and supplemental nutrients for India's poor in a detailed manner. It also clearly articulated the ways in which those government schemes are to be implemented and identified the public officials who can be held accountable in the event of non-compliance. FCI was requested to provide food grains to the people in the drought hit areas. Next right is right to make reproductive choices. In a leading case of Suchita Shrivastava versus Chandigarh Administration, AIR 2010 Supreme Court, page number 235. In this case, an orphan woman of age 19 to 20 years who was already suffering from mild mental retardation was found pregnant while staying in a government-run welfare institution. A woman's right to make reproductive choices is a dimension of personal liberty within the meaning of Article 21, and the reproductive choices can be exercised to procreate as well as to abstain from procreating. The women's right to privacy, dignity and bodily integrity should be respected in line with the conditions specified in the Medical Termination of Pregnancy Act 1971. Next right is right to choose one's partner. In case of Lata Singh versus State of UP and another, 2006 judgment, page number 2522, the Supreme Court held that right to marry a person of one's own choice is protected within Article 21 of the Constitution. The court also directed the police to take action against anyone who threatens, harasses or perform any kind of violence against the petitioner, the petitioner's husband or relatives of the petitioner's husband in accordance with the law. This was one of the first cases that validated the right of a major to choose a partner of his or her own choice, be it an intercaste marriage. Right against indecent representation of women. In a leading case of Chandra Rajkumari versus Police Commissioner Hyderabad, AIR 1998, and it was given under page number 302. It was held that beauty contests in their true form are not objectionable. However, if there is indecent representation of a woman or if there is any matter derogatory of women, then it would offend the Indecent Representation of Women Act of 1986 as well as Article 21 of the Constitution. Next right is right to go abroad. In case of Satwant Singh Sani versus D. Ramaratnam, AIR 1967, Supreme Court, page number 1836. A person living in India has a fundamental right to travel abroad under Article 21 of the Constitution and cannot be denied a passport because factually a passport is a necessary condition for travelling abroad, and by withholding the passport the government can effectively deprive him of his right. Right against harsh living condition of prisoners, and the case is Sunil Batra versus Delhi Administration and others, 1978 judgment on page number 1675. The Supreme Court held that during the prisoner's time in jail, the jail authorities do not have any right to punish, torture or in any way discriminate against them without the explicit permission or orders of the court. It was held that the provisions of the Prison Act 1894 must not be misinterpreted as a right or freedom to torture the inmates. The right to privacy. Right to privacy sounds like a very basic and obvious right to possess, but for a long time it was not recognized as a distinct right by the government because of not being mentioned explicitly by the drafters in the Constitution of India. Over time, there has been a growing recognition of a person's autonomy over his or her personal body, mind and information, which has been given due emphasis by the courts in various judgments. One of the most important judgments related to right to privacy came in the case of Justice K.S. Puttaswamy versus Union of India, AIR 2015, Supreme Court, page number 3081. The bench anonymously held that right to privacy was a part of one's right to life granted by Article 21 and included the right to keep personal information private. While it upheld the constitutional validity of the Aadhaar card, it struck down certain provisions of the Aadhaar Act 2016, right to health and medical assistance. The right to life, of course, cannot be upheld if every person is not given access to proper health and medical assistance. It is most primary prerequisite to living a full life. However, sometimes doctors and medical institutions hesitate to assist the ailing person due to fear of long formalities and complications, especially in medico-legal cases. In a leading case of P.T. Parmanand Katara versus Union of India, this case is of 1989 and given on page number 2039. It was recognized that Article 21 renders paramount importance to the preservation of human life. Thus, it is the obligation of all medical professionals to give immediate health assistance to all patients without being put under any legal impediment. It was decided that no medical professional shall be harassed for any investigation, and he or she would not be asked to testify in court unless necessary and absolutely relevant. Next right is right to sleep. Right to sleep is a distinct part of one's fundamental right, which protects against any action of the state leading to the unlawful deprivation of a person's sleep. Re Ramlila Maidan incident versus Home Secretary and others. This is a 2012 judgment given under Criminal Law Journal, page number 3516. Was the case which led to the establishment of this right. The court acknowledged that sleep is an essential part of a healthy life and a necessity for the maintenance of individual peace. Thus, it held that every person is entitled to sleep as comfortably and freely as he breathes. If any person sleep is disturbed without any reasonable justification, it amounts to torture and is a violation of his human rights. Therefore, making the sleeping person flee and causing mayhem at the location was held as unlawful, since there was no illegal activity taking place there. The next important right is right to die. The right to life confers upon the person the right to live a full life and dictates that state cannot interfere in this right except through the procedure established by law. One might say that such a view is inhumane because a person, especially one who is depressed or frustrated to the point of wanting to die, should not be criminalized for attempting suicide. A person has the right to life, which should naturally imply the right to end his life too. The landmark case in this matter was Common Cause versus Union of India, 2018, Supreme Court, page number 1665. A 5-judge constitution bench ruled that right to life also includes a person's right to die with dignity and thus allowed passive euthanasia, that is, the will of the patient to withdraw the medical support in case of slipping into an irreversible state of coma. Thus, currently active euthanasia is illegal in India just as in most other countries. On the other hand, passive euthanasia is legal in our country subject to certain strict guidelines. Right to a healthy environment. Nature has showered us with its gift since the beginning of time, and these gifts and resources act as a backbone of human existence. A clean, healthy and harmonious environment is one of the necessities for the true enjoyment of life, and thus it comes as no surprise that a right to live in pollution-free environment is included in the expansive right to life. Freedom from noise pollution. In this fast-paced, chaotic urban world, noise has become a major deterrent to a peaceful and healthy lifestyle. The huge public loudspeakers, noisy firecrackers and even the incessant honks of vehicles on the roads have become a source of great annoyance and also of serious health hazard. In a leading case of re-noise pollution case of year 2005, the court addressed the issue of noise pollution and moved a step towards controlling it. In this case, a petition was filed against the use of loudspeakers in religious congregations, political rallies, social occasions, etc., and the use of firecrackers, which created a lot of noise pollution and disturbance. The court acknowledged the grave adverse effect of loud noise and gave certain directions to prevent prohibition of bursting noisy firecrackers at night, fixation of cap on the noise level of loudspeakers and many more. The environmental pollution situation probably stands on a better legal platform than it did a couple of decades ago, but there is still a very long way to go in its implementation if we want to save the earth in the face of alarming climate change statistics. Prevention of sexual harassment of working women. When we think of a good life, it probably includes living with respect in the community without any unfavorable action taken by other against you. However, in this patriarchal society, women are often treated as sexual objects meant for the pleasure of men, and it leads to unwanted sexual advances towards them. Keeping this issue in mind, various provisions have been ordered by the court and implemented by the government to prevent sexual harassment of women, which can be mainly credited to the following landmark case, Vishakha and other versus State of Rajasthan. This case is of 1997 on page number 3014. In this case, a writ petition was filed to prevent the hazards to the safety of working women in the wake of an alleged gang rape of a social activist in Rajasthan village. The court defined sexual harassment and laid down certain guidelines for prevention of sexual harassment in the workplace, which include but are not limited to following the duty of the employers and responsible people to prevent sexual harassment, duty of the employer to provide a safe and appropriate working environment for the women, etc. Concluding the topic, I can say that the term natural rights has evolved into the right of life and personal liberty in modern times. The right to liberty is one of the fundamental human rights that are sought to be realized and inscribed in the preamble of the Constitution. In addition to Article 21, libertarian ideals are protected by the Constitution, which serves as each nation's primary governing document, as been covered in previous chapters. Since it is a basic human right, it is essential to expand its scope in order to support the growth of human character. The term had numerous interpretations and today even encompasses a number of socio-economic rights and other rights. The right to life and personal liberty has a wide ambit which is only growing over time. There has been increasing awareness about the various aspects of a person's life which he or she is entitled to control and which would thus facilitate the enhancement in quality of his or her life. This right has been described as the heart and soul of the Constitution of India by the Supreme Court and certainly proves to be so, representing the very basic necessities of human life. The judiciary has broadened the definition of right to life via number of cases. The rights listed in this manner by the courts are referred to as unenumerated rights, which are those that are not expressly acknowledged but are still included via interpretations. The fact that majority of people are not even aware of these rights is one of the largest difficulties now facing the preservation of life and personal liberty. Even though these rights fall under the umbrella of liberty, they are not specifically listed anywhere. The main challenge is to determine the scope and significance of this duty to educate the public about their rights, which are included in the concept of personal liberty, and to properly carry it out. Living would be tough if one were to lose the means of subsistence, which would also rob life of its real meaning and purpose. But if the right to a living is not regarded as a component of the right to life, such a denial of life would not be in accordance with the legal requirement. Another challenge with judicial activism is that the introduction and adaptation of public interest litigation has resulted in major change in terms of a new regime of citizens' rights and obligations, as well as new tactics of state responsibility. Thank you and have a nice day.